Third semester BCom examination March April 2023 NEP Commerce paper Company Law and Administration. Section A 8 questions ಇರುತ್ತೆ. ನಾವು ಎನಿ 6 questions ಅಟೆಂಡ್ ಮಾಡಬೇಕು. First one, what is prospectus? Prospectus refers to a formal legal document which is required by and filled with Securities and Exchange Commission that provides details about an investment offering for sale to the public, or a prospectus contains the facts that can investors need to make an informed investment decision. What is doctrine of ultravirus? It is a Latin word made up of two words. Ultra means behind, virus means power or authority. So anything which is behind power or anything authority is called ultravirus, or anything which is behind the objective of the company as specified in the memorandum of the company is called ultravirus. What is debenture? Debenture refers to a certificate of agreement of loan which is given under company's stamp and carried as the underwriting that the debenture holders will get a fixed and principal amount whenever the debenture matures. Who is called as director of the company? Director is a person who is charge of activity, or director is a person who leads, manages, supervises an organization, program or project. What is resolution? A resolution is an agreement made at a meeting conducted with the aims of making changes to the company. What is committee meeting? A committee meeting consists of a named subgroup of people within an organization who can come together to fill a predetermined function. What is winding up of company? Winding up of company is the process in which company ceases to exist anymore as a legal unit and its possessions are made in order to discharge claims of its creditors and members. What is audit committee? Audit committee is a major operating committees of a company board of directors that is in charge of seeing the financial reporting and disclosure. Next to section B ಎಲ್ಲ 4 marks questions, 5 questions ಕೊಟ್ಟಿರ್ತಾರೆ, 3 questions ಅಟೆಂಡ್ ಮಾಡಬೇಕು. First one, state any 4 features of company. Incorporated association. A company comes into existence on incorporation or registration under the Companies Act. It may be incorporated either as public company or private company. If not registered as a company under any law, it becomes an illegal association. Separate legal entity. A company formed registered under the Companies Act is distinct legal entity. It means an independent person who acquires such rights and powers to get its own legal identity. Perpetual succession. Perpetual means forever, so that once the company is created by the process of law, it can be ended by only the process of law. Men can come, men may go, but company runs forever. This character of company is called perpetual succession. Company seal. It is nothing but an official signature of a company, just like a stamp. Company seal affixed on the document of a company. It can be used as evidence to sue in the court. Limited liability. Liability of the members in the company are always limited up to the shares in the company. Here liability means the legal responsibility to do the things or to restrain from doing something. Next question, state the difference between memorandum and article of association. Basis, memorandum of association, article of association. Meaning, it is the fundamental document which lays down the objective of the company. It is also known as character of the company. It is the subordinate document which provides rules and regulations for the internal working of the company. Area of relationship. It defines the relationship between a company and outsiders. It defines the relationship between company and its shareholders. Status. Memorandum of Association is a fundamental document of a company. Article of Association is a subordinate documental to Memorandum of Association. Purpose. The main purpose is to define limit or scope of company's activity. The main purpose is to provide directions for the internal management of the company. Next question. Explain the features of equity shares. Meaning, equity share refers to a stock or capital stock of a business entity which represents the original capital paid into or invested in the business by its founders. It serves as a security for the creditors of a business since it cannot be withdrawn to the determinant of the creditors. Equity shares carry voting rights. Rate of dividend is not fixed. Equity shares do not carry prudential rights over preference shares. Question. Explain the powers of managing directors. To supervise and control the work of employee of the federation, to sanction expenditure on establishment or purchase store subject to the approval of the board, to perform such other functions that may be delegated by the board from time to time, to sign on behalf of the federation and to conduct its correspondence, to supervise and control staff of the federation subordinates to him and to maintain their confidential files and impose penalties as per staff service rules, to arrange for sale and marketing of commodities to and on behalf of its members and the federation, to incur expenditure in connection with the rebagging or standardization of commodities. Question. What is annual general meeting? State its features. An annual general meeting is a meeting that official bodies and associations involving the public including companies with shareholders are often required by the law. An annual meeting called by the directors of a company that allows shareholders to stay informed and involved with the company decision and working. The following matter constitute ordinary business at an annual general meeting. Consideration of annual accounts, directors report and auditors report, declaration of dividend, appointment of directors in the place of those retiring, appointment of and fixing the remuneration of the statutory auditors. Next to section C, ಎಲ್ಲ 12 ಮಾರ್ಕ್ಸ್ ಕ್ವಶನ್ಸು. ಎನಿ 3 ಕ್ವಶನ್ಸ್ನ ಅಟೆಂಡ್ ಮಾಡಬೇಕು. 5 ಕ್ವಶನ್ಸ್ನ ಕೊಟ್ಟಿರ್ತಾರೆ. ಫಸ್ಟ್ ಒನ್, ಎಕ್ಸ್ಪ್ಲೇನ್ ದಿ ಅಡ್ವಾಂಟೇಜಸ್ ಆ್ಯಂಡ್ ಡಿಸ್ಅಡ್ವಾಂಟೇಜಸ್ ಆಫ್ ಜಾಯಿಂಟ್ ಸ್ಟಾಕ್ ಕಂಪನಿ. First one, incorporated association. A company comes into existence on incorporation and registration under the Companies Act. It may be incorporated either as public company or private company. If not registered as a company under any law, it becomes an illegal association. Separate legal entity. A company formed registered under the Companies Act is distinct legal entity. It means an independent person who acquires such rights and powers to get its own legal identity. Perpetual succession. Perpetual means forever, so that one the company is created by the process of law, it can be ended only by the process of law. Men can come, men may go, but company runs forever. This character of a company is called perpetual succession. Common seal. It is nothing but an official signature of a company, just like a stamp. Company seal fixed on the document of a company. It can be used as evidence to sue in the court. Limited liability. Liability of a members in the company are always limited up to the shares in the company. Here liability means the legal responsibility to do a thing or to retain from doing something. Separate property. A company can hold property, acquire, sell, lease, mortgage, gift, or otherwise transfer property in its own name because of its legal identity. It simply means that a company can be transfer or transfer of a property. Company can be sued or sued. A company is a legal person who can file a suit against another and against whom a suit can be filed in his name. Anyone can sue the company can also sue the other. Next, disadvantages of joint stock company. A determination of character. A company through registered in England would assume an enemy character if the person in de facto control of company are residents of an enemy country. For benefit of revenue, the separate existence of the company may be disregarded when the only purpose for which it appears to be formed in the evasion of taxes, fraud, or improper conduct. A company was restrained from acting when its principal shareholder was bound by a restraint covenant and had incorporated a company only to escape the restraint. Agency, trust, or government company. Separate existence of a company may be ignored when it is being used as an agent or trustee. Under statutory provision, Act of sometimes imposes personal liability on person behind the will in some instances like where business carried a behind 6 months after the knowledge that the membership of a company has gone below statutory limits. Formalities and expenses. Incorporation is very expensive affair. A number of formalities to be complied with the both as to formation and administration of affairs. Company not a citizen. Company is a legal person but not a citizen, neither under the provisions of Constitution nor under a Citizenship Act. Next question. Explain the different stages of formation of a company. According to Section 3 of Companies Act 2013, basic requirements of forming a company is follows. Formation of a public company involves 7 or more than to subscribe their number of memorandum and register the company for any lawful purpose. Similarly, 2 or more people can form a private company. One person can form one person company. Registration or incorporation of a company. According to Section 7 of the Companies Act 2013, filling of company's registration company with register, memorandum of association and article of association of the company and all subscribers have to sign on the memorandum. The person who is engaged in the formation of a company has to give a declared regard compliance of all its requirements and rules of the Act. A person named in the article also have to sign the declaration. Each subscriber to the memorandum and the individual named as first director in the article should submit on affidavit with the following details declaring regarding non-conviction of offence with respect to formation, promotion and management of company. He has not been found guilty of fraud to any company in the last 5 years. The document filled with register are completely and true to the best of his knowledge. Address for correspondence until the register office is set up. If the subscriber to the memorandum is an individual, then he need to provide full name, residential address, nationality along with the proof of identity. If the subscriber is a body corporate, then prescribed document need to be provided. Individual mentioned as subscriber to the memorandum in the article need to provide declared specified in print above along with the director's identification number. The individual mentioned as first director of the company in article must provide particular of dangerous interest in the other firms along with their consent to act as the director of a company as per the prescribed form. Next stage, issuing the certificate of incorporation. Once this register receives the incorporation and company registration papers, the register all information and documents issue the certificate of incorporation in the prescribed manner. Corporate identity number. The register along allocates CIN to the company which is distinct identity for a company, and the allocation of CIN is 1, and from the company incorporation date, the certificate carries this date. Certificate of Incorporation. It is a legal document required at the time of company formation. It is said to be measured by the shares and that are shareholders. A private limited company cannot offer their share to general public, so it has to be traded in the public stocking exchange only. Next question, explain the different types of preference shares. First one, cumulative preference shares. The holders of cumulative preference share are entitled to receive a fixed percentage of dividends before anything is given to other classes of shareholders. If the company has no profit or inadequate profits in any year to declare dividend, the areas of dividend would accumulate and become payable out of the future profits. Non-cumulative preference shares. Non-cumulative preference shares are entitled to a fixed state of dividend in the first instant before anything is given to other types of shareholders. In case the company has no or inadequate profits in any year to declare dividend, then the areas of dividend do not accumulate and become payable out of the future profits in case of these shares. Participating preference shares. The holders of these shares, in addition to the fixed percentage of dividend, are also entitled to participate in the surplus profits of a company along with the equity shareholders. There is a specific or special provision in the Articles of Association of the company giving the holders of these shares special rights to participate in the surplus profits. Non-participating preference shares. The holders of these shares are not participating preference shares will get only a fixed rate of dividends of the course in the first instant before any dividend is paid to equity shareholders, but they are not entitled to participate in the surplus profits of the company. Convertible preference shares. The holders of convertible preference shares are given to the rights to convert their shares into equity shares later on after a certain period. Non-convertible preference shares. The holders of non-convertible preference shares are not given the rights to convert their shares into equity shares later on. Redeemable preference shares. Redeemable preference shares are those preference shares which can be redeemed, returned, or paid back even during the existence of a company. Those shares can be redeemed as per the terms of issue either at a definite date after the expiry of a stipulated fixed period. Irredeemable preference shares. Irredeemable preference shares are those preference shares which will not refundable until the company is wound up. Next question, explain the rights and duties of company secretary. Administrative and executive functions such as overall control and day-to-day administration of office guiding the subordinate officers of the department as well as the activities of allied department. Advisory function which is include advising the ministers on all the matters regarding decision and supplying whatever information is needed by the ministers. To attend the administrative functions such as correspondence, maintenance of accounts and records, supervision of staff and arranging for audit of a account. To conduct activities of the club or association such as registration and new members, collection of fees, etc. The convenience meeting of members or executive committees are to be prepared required document and minutes of the meetings. To advise the managing committee on various matters related to the association and to execute the decision of the managing committee. Next question, what is minutes of meeting and explain its contents. Minutes of meeting are written or recorded document that is used to inform attenders and non-attenders about what was discussed and what happened during the meeting. First point, notice. Notice is a legal communication about the day, date, time and venue of meeting. Under a company law, there should be a 21 days here clear notice to hold meeting of memorandum of the company, whereas a 7 days notice is required to hold meeting of board of directors. Agenda. Agenda refers to the business to be translated at the meeting. In case of meeting of members, there would be a few matter to be discussed. Therefore, the agenda is built into the notice itself. The agenda for other meeting is to be drafted to cover the points to be discussed. The concept of corporate governance has come to stay. Companies are now professionally managed, and the Securities and Exchange Board of India requires that committees be formed. Quorum. Quorum refers to the minimum number of members who must be presented at a meeting in order to constitute a valid meeting. A meeting without the minimum quorum is invalid. 5 members personally present in case of a public company and 2 members present not by proxy in case of private company shall be quorum for the general meeting of a company. Proxy. When a member is not able to personally attend a meeting, he can depute another person to attend the meeting on his behalf. Proxy forms are to be deposited with the company sufficient in advance before the commencement of the meeting. Any member of a company entitled to attend the vote at a meeting of a company shall be entitled to appoint another person, whether a member or not, as his proxy to attend the vote instead of himself. Chairman. The chairman is head of the meeting. Generally, chairman of board of directors is the chairman of the meeting. The members present in the person at the meeting elect one of themselves to be a chairman there of one on a show of hands. If there is no chairman or he is not present within 15 minutes after the appointment time of the meeting or unwilling to act as a chairman of the meeting. Voting and demand for poll. If the majority of hands raise their hands in favor of particular resolution, then unless a poll is demanded, it is taken as the passed. Voting by a show of hands operates on the principle of one's member, one vote. When a demand for poll is made, he must order the poll to be taken. The chairman may order a poll when a resolution proposed by the board of in lost on the show of hands. Amendment. Amendment means any notification to a motion before it is put to vote for adoption. Amendment may be proposed by any member who has been already spoken on the main motive or has not previously moved on amendation thereto. A motion must be in written and signed by a mover and put to the vote of the meeting by the chairman. Adjournment. Adjournment means suspending the proceeding of a meeting for a time being so that the meeting may be continued at a later date and time fixed in that meeting itself at the time of such adjournment or to decide later on. The majority of members at a meeting may move on adjournment motion at the meeting. The chairman cannot adjourn the meeting at his own discretion without being a good cause for such adjournment. An adjournment meeting is merely the continuation of our original meeting and therefore a fresh notice is not necessary. If the date, time and place are holding, the adjournment meeting are decided and declared at the time of adjourning it.